Good morning, everyone, and welcome to the 6th in our series of breakfast briefings with me, Kaz Carrington of KLC. Just to let you know that Melanie Whittle of KLC will be answering your questions electronically this morning. Thanks, Melanie. But if we don't manage to answer your question as we go along, don't forget that you can email into us on this email address, klc@klcemploymentlaw.com. Also a shout out to Liv Harris of GoHo, who's providing technical support for me today. You know how much I need it, Liv, so thank you very much. Okay, off we go, and let's have a look at the programme for this morning. So as you can see, we're going to look at the law, the relationship the law has with case law, potentially fair reasons for dismissal, automatically unfair reasons. You won't see the words automatic unfair reasons in the statute anywhere, but dismissals will be considered unfair if they are for certain reasons. We'll look briefly at the rules of natural justice and the ACAS code and the interaction that they have with each other, qualifying service to bring a claim of unfair dismissal. As we all know, sometimes you don't need any. Fixed term contracts, the non-renewal of those and the relationship with dismissal and unfair dismissal, and then finally constructive unfair dismissal. So quite a lot to get through, so let's start off with the law. So as you all probably know, if you've looked recently in the Employment Rights Act, section 98 1 to 3 has the reasons for dismissal. So what we have to show as employers, if we're going to dismiss somebody fairly, is the reason, or if there's more than one, then the principal reason for the dismissal. So if we look at section 98, we can see listed that we have capability or qualifications. So capability will be with reference to somebody's aptitude or skills, or it could be their incapacity to do the job. So it could be to do with their physical or their mental health. Qualifications will be in reference to diplomas, qualifications, degrees, that sort of thing. Then we go on to conduct, obviously how somebody behaves in the workplace, and we'll look at, you know, the misconduct and the gross misconduct issues. Then we come on to redundancy. Is the employee redundant? On then to statutory bar, that is, will it be lawful, legal to continue employing this person? If it isn't, then obviously that's in contravention of the law, and that's a statutory bar. So for example, if somebody didn't have the correct permissions to work in the UK, that would be a statutory bar. And then we come on to the catch-all, as some people call it sometimes, there's some other substantial reason, the operative word there being substantial. So it's got to be a reason that actually justifies dismissal. Now, over the years, and we'll see that case law informs us, but some others, the substantial reason, or SOSA, as I'll call it from now on, covers myriad reasons. So for example, where we have somebody who's intermittently, persistently absent, but there's no underlying medical condition, even though they're actually genuinely ill, that's a SOSA dismissal if we dismiss them for that reason. Where we're changing contracts and somebody doesn't want to agree to the change in their contracts, we might dismiss and then re-engage. That would be a SOSA dismissal. Third party pressure dismissal, SOSA. Breakdown in relationship, SOSA. If somebody's incarcerated, SOSA. Temporary cover, when the person who's the incumbent of the job comes back, dismissal. So we know that because of case law over the years. So moving on, it's our obligation to show the reason for dismissal. So when we're talking about fairness, and obviously we're talking about trying to dismiss people fairly, because we want to be reasonable, fair, good employers, but also we want to keep the right side of the law. So we have to show that reason for dismissal. So if we have a claim of unfair dismissal made against us, as you'll know, it's our duty to demonstrate that what we have done is for a potentially fair reason, and that we've done it fairly. We've actually operated a fair process. If we can't show that potentially fair reason, one of those reasons under section 98 of ERA, then really it's sort of game over, because what happens is that if I can't demonstrate why I'm dismissing somebody, that person might well assert that it was for a reason which is going to be considered to be unfair by the tribunal. It's going to be one of those in inverted commas, automatic unfair dismissals. And as you can see there, there's about 60 of those. So dismissing somebody in contravention of a statutory right, they're trying to assert, I know, it could be, I know, a family leave, or they want to assert their rights under the working time regulation, and so on and so forth. That's why it's so important to be absolutely clear that we can identify the behaviours and therefore get in the right process, and therefore our labelling of the dismissal will be correct. Now, very often what happens is that employers try to manage performance and behaviour. And one of the most frequent difficulties and mistakes that are made is that sometimes non-culpable behaviour is really treated as culpable behaviour. So, for example, somebody who is incapable of doing the job for whatever reason, it could be that they haven't got the skill or aptitude, they just haven't been able to take on the learning that we provided, and it's not working out. But rather than treat that as an incapability, as a non-culpable behaviour, employers treat it as really punishable by warnings. If you don't get better, if you don't actually improve your behaviour, then you have another warning, rather than giving people time to improve. And that's where we see this crossover of culpable, non-culpable behaviour. And one of the ways to avoid getting stuck into that error is to always assume, unless it's absolutely blindingly obvious, that performance issues are the non-culpable kind. It's not that the person is just being annoying and won't do the job, it's that they can't do. And then if you later find that, of course, they have the capacity, they have the capability, it's just that they won't do it, then obviously we can switch to a culpable procedure, like a conduct procedure. In terms of the requirements at section 98(1)(a) to actually show the principal reason for dismissal, that's been tested at the highest level. It was a House of Law case, now trading obviously as Supreme Court, and a case was Smith versus City of Glasgow and District Council, and it was where the council had quite a few reasons they thought they wanted to dismiss an individual for, and those reasons were culpable reasons and non-culpable reasons. They were reasons relating to capability, but also they were conduct. They couldn't show the principal reason, and therefore it was an unfair dismissal. So always remember, it's not good just to throw as many issues into the pot as you possibly can, thinking that that's going to make the dismissal fairer. It's much better to be clearer about what your principal reason is and stick to that and have a fair process. Now, what happens if we do put the wrong label on the dismissal, or we sort of treat somebody unfairly because we've got them in the wrong process? Well, if we merely mislabel the dismissal, then it's not necessarily fatal. The most famous case for this is Wilson versus the Post Office. It was a Court of Appeal case. And actually it was about establishing that where we have intermittent persistent absence that's genuine, but there's no underlying medical condition, that the proper and correct reason for dismissal is some other substantial reason, irregular attendance. Now, what happened in this case is that the Post Office actually talked about capability in their dismissal letter. The tribunal picked up on that and felt that it was unfair because this was clearly somebody who was incapable of doing the job, but the Post Office had just merely given warnings to improve attendance. Now, actually, for a irregular attendance SOSA dismissal, that is perfectly the correct process. And so when this tribunal found it was unfair, it got appealed. EAT and Court of Appeal said, look, no, this was merely a mislabelling. We know what the Post Office meant. It didn't actually put the person at a disadvantage at all. So here what we're saying is sometimes a mislabelling, as long as the person isn't disadvantaged, will be okay, but don't bank on that. And very often when we put the wrong label on behaviours, we end up treating that person in the wrong way, in an unfair way. So it's always best to make sure we're in the right process to start with. Of course, if we're just trying to circumvent fairness by, oh no, we'll label it this way, we'll be able to exit the person much more quickly because we're using this procedure rather than one that's a longer procedure, that is obviously going to be unfair. We're going to get found out with that. Now, another part of section 98 is 98.4, and that's the piece of law that really tells us all about mitigation. So even where we have followed a fair process, we have identified the correct behaviours and therefore the correct potential reason for dismissal, if we don't take into account everything to do with this person and the case, then it will still be possibly unfair. And this is what Section 98.4 tells us. In all the circumstances, is it a sufficient reason to dismiss? Take into account equity and the substantial merits of the case. That's saying to us, look at everything that's gone. So what about a person's record? What about their length of service? What are the circumstances of this case? Now, I said this till I'm blue in the face, but I often hear, as I travel around talking to people, organisations that say, oh, well, if it's gross misconduct and we find that somebody has done X, then we will always dismiss. Well, that might be the case, but sooner or later that might come back to bite them, because there will be circumstances where actually in all the circumstances of the case, it was not a reasonable or a sufficient reason to dismiss. It wasn't fair in all the circumstances. So always bear that in mind. That's something to always make your line managers, when you're sitting in with them at that disciplinary hearing, if it's dismissal looking like a dismissal, the final things we want to be saying to our line managers: have you thought about these things? Have you thought about the circumstances, any mitigating reasons for the behaviour before a decision is made? Okay, so case law, what a relationship does that have with the law? Well, it interprets the law. It tells us how to behave, and in terms of Section 98.4, we have certain cases which have given us principles. For example, the range of reasonable responses test. If no reasonable employer would have dismissed, then it will be unfair. Jones versus Ice and Frozen Foods. With regard to conduct and capability, when we're looking at not actually having to prove that somebody has committed an act of misconduct or prove that they are actually incompetent, we have to show that we formed a genuine belief on reasonable grounds after a reasonable investigation. BHS versus Birchall. So landmark cases which have really informed us and told us how we interpret the law. And as I mentioned before, we now know what SOSA covers because of case law, because we have lots and lots and lots of cases going back over the years which say, yes, in this circumstance, it's a SOSA dismissal. So we're talking about looking at the reason for dismissal in different ways. As you can see, there's certain dismissals where we just have to show that we formed a reasonable belief. Other dismissals have to be a matter of fact. So, for example, redundancy and statutory bar, they have to actually be facts. So we have to show that as employers, we have a diminishing requirement for work of a particular kind to be undertaken in this place of work. If it's a statutory bar, it has to be a fact, which is why when it comes to statutory bar, let's take for example, somebody who we believe doesn't have the correct permissions to work in the UK. We might know that or think we know that because we might have even been informed by the Home Office, but sometimes that information isn't entirely correct. And employers who have just gone ahead and just said, okay, you're dismissed without any process, when the individual has been found to have been actually a legal worker, that dismissal has been unfair. So what we do, we always, in the background, have running an alternative process. In the background, we're always thinking, if this person actually is a legal worker, is the process we're using fair? So it's almost like in the alternative, a SOSA dismissal, we have formed a genuine belief on reasonable grounds after reasonable investigation that this person isn't legal. So we always have some form of process so that we can expedite a fair dismissal, even if it shows or if it's shown that that person is a legal worker. Okay. Obviously, we need a fair process. Again, over the years, the way that we've established that is by case law. Polkey versus Dayton Services. Polkey case was the case that gave us the principle, the concept that you cannot ever dismiss anybody fairly, really, without employing a process of sorts. And once you've got that process, you jolly well stick to it. So if you've written it down, it has to be to the letter that you follow it. Because if you don't, even if We have a potentially fair dismissal. We could even have a person who's owned up to a gross misconduct offence. If we haven't followed our laid down procedure, it could still be procedurally unfair. Now, we can, of course, put that right sometimes if the person appeals. So again, case law has advised and informed us that there is no procedural error that an appeal can't put right. So if we use our appeal as a complete rehearing, you realise we've mucked up in procedure. Actually, that's why the person's appealing, because they say the procedure hasn't been followed. We now have a fair process. We now rehear the matter. We can put what was going to be an unfair dismissal actually right, and that will now be a fair dismissal. Double-edged sword, really, for the employee in those circumstances. Of course, if the individual doesn't appeal, we still may have a procedural unfair dismissal, but we have the opportunity of asking for a pulky reduction. That is, look, you know, if we had followed a fair process or a laid down process, the percentage chance of the person still being dismissed is anything from 1% to 100%. So we can get a reduction potentially in the compensatory award. Now, rules of natural justice, you might have heard that mentioned in other aspects of life, not just at work and employment law, and the ACAS Code of Practice on disciplinary and grievance procedures. Well, the ACAS Code of Practice has a lot of case law and natural justice embedded in it. And I often say, look, as long as you've written your policies and procedures, your disciplinary procedures and other procedures with the ACAS code in mind, that's fine. You can almost sort of think, well, that's embedded in there. We haven't got to look at that again. When we're talking about natural justice, thinking about the process and the way that you hear matters, it's all to do with how you would want to be treated if you were accused of doing something. So the allegations must be clear. It's no good saying to somebody who you believe has stolen something, it's no good saying to them, oh, we believe monies have gone missing. You need to say that the allegation is of theft, otherwise the person doesn't know what they're accused of. So very clear in the allegations. We provide all the evidence, don't we, before the hearing for the individual to look at and their accompanying person to look at. As far as we possibly can, we let the accused person know who their accusers are, who has made witness statements and what has been said. When we looked at investigations in a breakfast briefing before, remember we talked about sometimes being able to anonymise those witness statements when we have good reason to do so. But as far as possible, we would always give over the substance of the accusation. An unbiased approach. We always have, again, as far as we possibly can, somebody who does the investigation, a different person hearing the matter and a different person hearing the appeal. We're showing an unbiased process. We have fresh eyes and fresh ears each stage of the procedure. And of course, there is the right to be heard. Lots of cases we see, in fact, the case that told us about the benefit of appeals, you know, there's nothing that can't be put wrong appeal, Khan versus Stripe Star. In the first round of his disciplinary hearing, he wasn't even allowed to speak. He actually appealed and they put that right. But obviously it's the right to be heard. That's why it's called a hearing. And obviously the Statutory Code of Practice, as well as the law, provides elements like the right to be accompanied and the right to appeal. So these are all embedded, if you like, hopefully in our policies and procedures. Qualifying service is often a topic that comes up when people ask us for advice. And one of the questions we'll ask is, how much service does that person have? What we're looking at is a risk evaluation for the client. But what's always at the back of our minds is that even if somebody doesn't have the requisite 2 years continuous service to bring a claim of unfair dismissal, if they can assert that the reason they're being dismissed is for one of those automatically unfair reasons, they do not need 2 years service. And so we're always trying wherever we possibly can to stick to our procedures to offer a fair process for everybody, because just because somebody doesn't have service doesn't mean to say, oh, well, we'll circumvent all that and we'll just dismiss them. I mean, obviously for reasons of fairness and professionalism, but also because actually that might be somebody who can say, actually, they dismissed me because I said I wanted to take paternity leave. I don't need any service for that, and that's what I'm going to claim. There's also another little wrinkle as well, and Section 97(2)(b) of the Employment Rights Act puts an obligation on us. Well, actually, the law just does it for itself, really. If somebody has 103 weeks service, continuous service, and we dismiss them thinking, well, they haven't got 2 years service, unless the reason we are dismissing them can be demonstrated by us as being gross misconduct, then the law adds on an extra week, giving the individual 104 weeks service. Again, we're always careful not to play the numbers game, not to sort of be risky, again, for lots of reasons of equity and fairness, but also because of managing risk. Gross misconduct offences, this is obviously one of our conduct matters. We might have matters which are considered to be ordinary misconduct and might merit a first written warning or sometimes a final written warning if they are committed. But we always list, don't we, our items that we consider to be gross misconduct. And again, we do this to demonstrate these are the types of behaviours that if we find that you have committed, basically you will be or could be summarily dismissed. And it says in that bullet point there that, you know, we should be realistic about this. That means that we always say this list is non-exhaustive, but if you don't include items in that list that really are obvious for your sector, so if you're working in retail, you have something about, you know, till procedures, etc., then if you try to say, oh, that's gross misconduct, it might be that, well, if you thought it had been gross misconduct, you would have had it in your list, and therefore we're not accepting that's the case. Because even where we do list matters to be gross misconduct, actually it's up to the tribunal to decide whether it was or not. Ours is just an indication. By the way, there is no rule of law which says that it is only gross misconduct that can result in a summary dismissal. That's a dismissal without notice or pay in lieu of notice. Section 98(4) say the courts is wide enough to actually say, actually, if it's reasonable in all the circumstances to dismiss somebody who hasn't actually committed gross misconduct or hasn't got live warnings, which the next warning would put them over into dismissal, well, actually, that's allowed under Section 98(4). And the case to look at, if you want to look at that, is Stratford versus Auto Trail. The individual in this case had 17 spent warnings, and they were hearing a matter which wasn't labelled gross misconduct. It was downgraded to serious, but they actually dismissed him because actually in all the circumstances they didn't actually think that this person was going to improve. So again, these situations are not rare, but you should always try to stick to the general rule of you're only going to dismiss summarily for gross misconduct. But do bear in mind that you can dismiss without prior warnings in certain circumstances, or without live warnings, even if it's not gross misconduct. Okay, non-renewal of a fixed term contract. I want to touch on this because, again, this sometimes comes as a complete bolt in the blue to your line managers. In the Employment Rights Act, as you can see, Section 95(1)(b) era states that the non-renewal of a fixed term contract is a dismissal for the purposes of unfair dismissal. And therefore, we always need to be able to know why we're not renewing a fixed term contract. We also need to be able to use a fair process. And a good case, if you want to actually look at that, was Royal Surrey County NHS Trust versus Dismissal. Now, let me just go back to fair reasons first. Non-renewal of a fixed term contract could be because we no longer have work for somebody. That's a redundancy. Person may not necessarily get a redundancy payment because they haven't got 2 years service to qualify for redundancy payment, but that would be the reason we weren't renewing. So we've obviously got to have a potentially fair reason. It might be that their conduct isn't good enough, or their performance isn't up to it, or it could be that their visa has run out as a statutory bar, or it could just be actually that funding has been withdrawn and we no longer have the ability to be able to employ this person. That could be as some other substantial reason, but we have to fix with that potentially fair reason a fair process as well. In the Dismissal case, they actually didn't go give the individual the right to appeal and didn't actually help them find alternative employment in the organisation, and that made the dismissal unfair. So that's satisfying, if you like, the Polkey principle there. Constructive unfair dismissal, just touching on that very briefly. This is where, as an employer, our behaviour towards our employee is such that they may resign and say that our behaviour or our non-intervention in some situations is such that it has breached the fundamental term of a contract. It's breached generally trust and confidence, or we've done something else that has actually breached contract fundamentally. It could be, well, I've just stopped paying somebody. That's a fundamental breach of the contract. Allowing that person to resign and claim that they've been constructively unfairly dismissed. Now, obviously, the individual in this situation, the onus is on them to show that we fundamentally breached the contract. So that's the onus on the claimant. But if they are able to show that, and we haven't put forward a potentially fair reason for dismissal, then it's game over for us. So we are asked by the courts, and the Court of Appeal have stated this, that although it seems quite an odd thing to do, if somebody does claim constructive unfair dismissal, obviously the employer will try to deny, we haven't breached the contract fundamentally. What we did was not a fundamental breach of that contract. However, if we did breach the contract, then we did it for a potentially fair reason. It's pleading in the alternative. And though sometimes when you are filling out your ET3, your response form, your grounds of resistance, you might think, well, what could be a potentially fair reason? Because we don't actually think we've done this thing in the first place. But if we did, what was the fair reason? Sometimes it's difficult, but it's really important to try, because otherwise, if the tribunal finds that the contract's been fundamentally breached and we haven't put forward a potentially fair reason, then again, that's game over for us. Okay, just some top tips for us then. Have clear rules and procedures that are legally compliant, but stick to them. Remember, the procedural unfair dismissal, even though we have Polkey, doesn't affect the basic award. The individual would still get that. And if we have no process, that's going to be unfair altogether. So remember always, if it's a statutory bar, what's our potentially fair reason in the alternative? If, for example, it's an illegal worker that we think actually want to be able to say, well, actually, they are legal, but we treated them fairly anyway because we formed a genuine belief. So we actually have a fair process. The process must fit the reason, and our tone, our letters, the way we correspond with people, everything must be congruent with the issue. So if it's somebody who is very poorly, we are sympathetic. If it's somebody who's a poor performer, we're offering support. If it's somebody whose behaviour is, wrong, it's a conduct issue, our tone reflects that. And again, if it's not one of those big four reasons under section 98, 1 to 3, then obviously, is it a sufficient reason to dismiss? Never conflate warnings. Never say, well, you've got a warning for conduct now, and now you've got a warning for poor performance capability, and now you've got another warning for something else, or now you're dismissed. We can't do that, because we have to be able to show the fair reason, if there's more than one, the principal reason for dismissal. And make sure our managers understand how our procedure works, how to conduct themselves in hearings. Observe natural justice, not only observe it, but be able to show, be able to have a good audit trail. This is how we've behaved. Keep up to date with case law. Things change all the time, and it can change. The nuances can actually change the way that we decide matters, whether they could be fair and unfair. And remember, the service matters. And remember that appeals aren't a bad thing. Don't get resentful if people appeal against your decision to dismiss. They're helpful. They can put things right. And if we have made mistakes, they can actually put what could be an unfair dismissal right, so it could now be fair. Remember, the non-renewal of fixed term contract is a dismissal at law, so we need to have a potentially fair reason and a fair process. And obviously remember the BHS test. Have we formed a genuine belief on reasonable grounds after a reasonable investigation? We're consistent always in the way that we treat people or sanctions, but remember section 98.4. Remember, we have to take all mitigation into account. And obviously before the decision to dismiss is made, if you are sitting there advising your line managers, always ask them, is there any reason why we shouldn't dismiss this person? Have we taken everything into account? Okay, so that's really all I've got to say for this briefing. We're nearly at the end, but just to say thank you very much for joining me this morning. If you've enjoyed it, just to let you know that we're running a mini online law on tour on the 1st of December. The link is going to be in the chat for you to look at. It's going to be a 2.5-hour employment law update, bringing you up to date with everything that's happened in the last sort of 5 or 6 months. And have a look at that if you want to get booked on. All from me now is to say thank you very much for joining me again, and have a very good day. Goodbye for now.